present and wanted to address the no contact order at this time.
All right. Okay. Come on up.
This courtroom just got a lot more complicated. What started as a simple hearing about a no-contact order quickly turned into a tangled web of family trust and the limits of the law. The woman you're about to hear from isn't asking for sympathy. She's asking for understanding. She's a mother of 2, one child with special needs, and she's pleading with the court to drop the order so the father can be part of their lives again. But here's the twist. This father has a domestic violence history, and the judge knows it. The stakes? Not just legal, but emotional. Watch closely, because this case is about to test where compassion meets caution.
Hello.
Hi.
What's your name?
Rosa Bannock.
Say again?
Rosa Bannock.
Yeah, I know. All right.
I told you it's you.
I just said, make you say it again. Go ahead. What do you want to tell me?
I want to drop the no contact order because, as you know, we got 2 kids together. My daughter's disabled. She has a severe speech delay, and his sister is not a good third party person.
Wow.
She was sick. Yes. I'm sorry.
Okay.
As a person, I don't know why you wouldn't tell someone that you're giving your child meds, or even ask someone who works in the healthcare profession like I do about medication that a 4-year-old can have. She also has 5+ allergies, and they fail to acknowledge this. Okay. And it's just kind of disappointing to me. I thought she would be better than that. And I trust him more than I trust her. We just can't be around each other.
That wasn't a great endorsement, but
No,
okay.
look, there's this domestic violence thing. He has his own issues, okay? He has mental health issues. He needs to fix that, and he needs to fix it without me, okay? And I trust him with the kids 100%. We just cannot be together.
Notice that, even as she admits they can't be together, she still defends his role as a father. That's not something you see every day in domestic cases. There's a real emotional tug-of-war happening here, between what's safe and what's right for the kids. The court has to decide, is her trust enough to outweigh the risks? And for everyone watching, ask yourself, if you were the judge, would you let contact resume for the sake of the children, or keep the walls up for safety?
Got it.
Yes, he's fine with the kids.
So you're looking, and probably we should let everybody know you've appeared before me on another docket.
Yeah.
Right. What it sounds like to me you're asking is for no contact as it regards to children.
Yeah.
Is that?
Yeah. And if he gets inappropriate, I'll just block him and let him cool off.
Well, I just want to make sure that we're all on the same page regarding this.
Yeah.
Is there parenting time with reference to the kids that needs to be taken into account?
We don't have like a official custody order. I just give him the kids on the weekend because my daughter doesn't understand.
Pardon? Say again?
I give him the kids on the weekend because my kids don't understand. So his sister picks him up after work on Fridays because they don't have school on Fridays. And it's been really hard on my daughter. So I figured it was the best thing since she doesn't really understand what's going on.
Okay, so and during the week,
I have them because they go.
You have them full time. There's no. Okay.
Yeah, because they go to school out in Ann Arbor.
Got it.
Yeah.
Okay.
And Your Honor.
Yes.
Prior to changing contact, this may be another issue. He's on probation, I believe, by the 15th for domestic violence with the same party. And that might cause contact as well. I believe the no contact order in that case is still in place and was in place at the time of this. So I would be objecting to any change of contact in this case as well.
Here's where things get complicated. The prosecutor jumps in, reminding everyone that the defendant is still on probation for a previous domestic violence charge, with the same victim. That means the no contact order isn't just this judge's call, it's legally tied to another case. Changing it here could violate probation terms, which could land him right back in custody. The courtroom tension just shifted from emotional plea to legal deadlock.
Yes, ma'am.
I am in contact with his probation officer too, so
Well, just so that I'm clear, he's
eh,
been sentenced in that case,
Correct.
and as part of the sentence, there's a no contact probation.
I believe so.
Does anybody have an offense date on that case?
last year in September.
Mm-hmm. Maybe on this complaint, because this is charged as a second.
So the offense date was August 20th, 2024. He was sentenced on,
January 8th.
correct, Your Honor. And the conditions that were put in place on that case on 10/22 mirrored this case, so there is a no contact currently in place in that case.
Got it. You wanted to say something?
Oh, I was gonna go in front of the other judge too and just ask. I mean, I've already been in contact with his probation officer anyways.
Mr. Parody, you wanted to say something? Or?
Yeah, it looks like there's a review hearing on the 19th. There,
For their case.
for, yeah, the probation case.
All right. What I'm going to do then, what's my date after the 17th?
December 1st.
All right. So what I'm going to do in this case is I'm going to adjourn this case instead of to the 17th to December 1st, 2025 at 1 p.m. I'm going to since he's on probation and would probably have a more intense look at him, I'm going to see what they're going to do with regard to the no contact. So at this juncture, I'm not going to change anything. I will tell you that given the timing, so that you understand where I'm coming from, given the timing of the previous case, the sentencing on the previous case, and then these charges, I have some grave concerns about whether or not I'm going to allow contact.
This moment is crucial. The judge isn't being cold, he's being careful. Every word you just heard reflects the burden of judicial responsibility. He's acknowledging the family's needs but balancing them against public safety and past behavior. Judges in domestic violence cases often walk this fine line between giving families a chance to heal and protecting them from repeating the same cycle. It's not about punishment anymore, it's about prevention. And here the judge decides not yet. No contact remains for now.
I understand why you're telling me that. I'm just going to have some concerns about what might lead to a too close a proximity for my feeling to you in this case. Okay. So I'm not saying no forever, but right now I'm not going to change it. All right. Thank you. So this matter will be December 1st, 2025, 1 p.m.
Thank you. Thank you.
All right. Thank you. Bond will continue with its conditions. All right. Record should reflect we've had a brief bench conference in this case. I am going to adjourn this matter out to my next available date of November 17, 2025, 1 p.m. There may be, or there is going to be a request regarding contact until there's further discussion with the victim in the case. The court is not going to address this at this time. Also, we were unable to get a Bengali interpreter for today. So, all right. 17th at 1 p.m.
Thank you.
Thank you.
I'm gonna send you.
We just witnessed a real-life example of how justice has to navigate emotion, law, and love all at once. Rosa isn't trying to reconcile. She's trying to co-parent. But the court can't risk a relapse of violence or probation violations. The no-contact order stands until the probation court reviews it. This case shows how family dynamics and criminal law collide in ways that don't always have a clean resolution. So what do you think? Should co-parents with past DV history be allowed limited contact if both agree? Drop your thoughts below. And if you found this breakdown as gripping as we did, hit that like button, share this video, and subscribe for more real courtroom moments where law meets human drama.